Good evening, everyone.
Good evening.
All right, this is our last hoorah, last Zoom session for the semester. So tonight we're just gonna do we're gonna talk about the cumulative course review. I'm also gonna I'm not finished grading the second writing assignment. It is 40 of y'all, so you can imagine how that can be. But you will get your grades. I put them in Blackboard and send you and email you a copy of your graded paper. So you will get feedback. Let me see. So we'll talk a little bit about
I'm sorry, I have a quick question.
Go ahead. Go ahead.
Did you receive my email? Because lately, like, none of my professors have been like receiving my emails. I just want to make sure that you got my assignment.
Let me check. Now I know you're married, right? So is your email still the same, or is it Watlington?
Yeah, it's my email is my maiden name.
Erica Watlington. Okay.
Cool.
All right, yeah, I got essay. Yeah, I got it.
Okay, thank you.
All right. Okay. All right, let me go ahead and call the roll. Can't forget to do that. Lanaya Bates. All right. I got a Diva Brown just checking in. I saw her check in. Let me see. Yeah, I got a Diva Brown here.
Somebody said they're waiting in the waiting room.
Yeah, I just let them in. A Diva Brown. What about Tiki Brown? Oh, more people. Everybody come. Okay. They're rolling up in here deep today. Might as well just wait a few minutes. Let everybody come on up in here. All right. I guess most people are in here now. I got Lanaya Bates just signing in. Adiva Brown. I saw Tiki Brown as well somewhere. I see Tiki signing in. I thought I let her in. Yeah, I see you. Trenton Brown.
Here.
All right. Jalen Chambers. Nope. Okay. Kelandria Dodd. I thought I saw that person too. Maybe not. Kelandria Dodd. Jade Downs.
Here.
Okay, got you. Jasmine Dudley. Okay, not here. Todd Ford.
So, yep.
Got you. Ataya Harris. Nope. Sydney Hatmaker.
Here.
All right. China Hazel. Justice Hope.
Here.
All right. Caressa Johnson. Caressa Johnson. Vaughn Johnson.
I'm here.
Right.
I'm here.
I got you. Jalen Long. Jalen Long. Shia McFadden.
Here.
I got you. Brandon Merritt.
Here.
Got you. LaStacia Miller. LaStacia Miller. Nope. Okay. Elliot Moore.
Here.
All right, got you. Taylor Moore.
Here.
All right. Aaron Orr. Aaron Orr.
I'm here.
Okay. Cole Parks. Cole Parks. Bria Pearson.
Here.
All right. Gloria Pereza. I know I saw you earlier.
Here.
Okay. Tatiana Philomar.
Here.
All right, got you. Genevieve.
Here.
Mackenzie Richards.
Here.
Got you. Parrish Rippey. All right. Naisha Ruffin. Naisha Ruffin. Serenity Sanders.
Here.
All right, got you. Jasmine Smith. Jasmine Smith. Okay. Jalen Thompson.
I'm here.
All right. Stacia Tyson. Stacia Tyson.
I'm here.
Okay. Jeremy Vick. All right. CJ. I think I saw you signing in Washington. Clarence.
Here.
All right.
Here.
I got you. Erica Watlington, I got you. Jaden Williams. Jaden Williams. Okay, no Jaden. Latia Williams.
I'm here.
All right. And Zaria Woodford. Zaria Woodford. All right.
I'm here.
Who said I'm here? Oh, Zaria. Okay, remember. Okay.
I'm here too. I'm not really sure if I heard
I didn't
you.
hear you. Jaden Williams, yeah. I didn't hear you. I got you now though. Anybody else? Jeremy Vick, Jasmine Smith, Naisha Ruffin, Parrish Rippey. I think that was it. Cole Parks ever come in? Nope. Okay, we're gonna move on. All right. Okay, so tonight is our last Zoom meeting for the semester. All you guys have left is the final, which will be up on the 19th. So I think that's Thursday, if I'm not mistaken. So third, yeah, let me make sure. Yeah, Thursday the 19th. What was I about to say? The final will be up. So it's gonna be up. So that'll be when it's up. So it'd be good for you guys to go ahead and take it if you're ready. I'm going to keep it up initially until November 24th. So it's gonna be up for roughly 5 days. So and then once it goes down, then the next time I'll have it up is during the exam week, the exam period. So if y'all want to, I mean, the thing is, the semester's ending at Thanksgiving. So that means if you do your exams essentially this week, you'll be done for the semester. So that's the reason why I wanted to go ahead and offer it early to let people take it, because I know a lot of you guys want to go ahead and be done. You guys are doing well in the class. There's no reason for some of you guys to wait a long time. Just go ahead and knock the exam out, and you can have a carefree Thanksgiving and Christmas. So that's the plan. That's why it's going to be up on the 19th. So tonight we'll talk very briefly. We'll talk briefly. Just do a cumulative course review, kind of talk about, kind of skim over everything we learned, not really go into anything in depth, because I've already gone into everything in depth, but just kind of do a refresher and talk about how the exam is made up, or what the makeup of the exam is. So of course, a big thing I tried to teach this semester was the writing. It was a little bit harder to really stay on writing because I guess it's a little bit different being, I guess, all right, being on the clock on these Zooms, right? So we're kind of limited when it comes to how long we can talk on Zooms. So I like to keep the Zooms kind of direct and pointed, and not kind of go off on tangents, because it'll mess up, kind of waste our time. But I did want to really, really reiterate a lot of the writing stuff, which I'll actually do again in a few minutes, because I'm going to talk about the paper. So of course, once I talk about the paper, that's it. Don't turn it in. So we opened up, of course, with the writing workshop. Then we went to chapters 1 and 2, where we talked about the nature, purpose, and function of criminal law. Those are kind of introductory chapters. Very important chapter was chapter 2. We actually had a writing assignment which came directly from chapter 2, and that was the constitutional limitations. That was a chapter that taught us about what limitations the law itself had, meaning that law is even subject to law. So if you're going to put something on the books and say this is illegal, whatever that is you're trying to put on the books, or say illegalize or make illegal, there has to be a constitutional basis for it. So it has to also meet constitutional muster or jump constitutional hurdles. So that's what that chapter is about. That's why it's called constitutional limitations. So it's constitutional limitations to criminal law. So it's pretty much just telling us what laws have to go through in order to get on the books. And if they do make it to the books, what I guess what we can do as citizens, if we want to challenge a law, if we want to appeal and say, well, this law as it's written is unconstitutional. At that point, what happens when we challenge a law and it goes up to the court, whether it be the state court or the federal court, if it goes that high? What are the standards? What are we going to apply here? So we talked about stuff like overbreadth and vagueness. Essentially meaning we want laws that define what's legal and illegal, or tell us what we can and can't do. And also, we don't want laws that are so overreaching that it almost allows us not to even be able to conduct ourselves legally, right? So much stuff you can't do, just trying to get one thing, trying to stop one thing from happening, that you make kind of balloon it and make everything illegal, or a lot more stuff illegal than it has to be if you're trying to get that one thing. So that's what we call it, overbreadth. The law is too essentially the law is too wide and is covering too much activity for it to be constitutional. Vague, of course, meaning that we want laws to be well written, so we know exactly what we can do, what we cannot do, what we're not allowed to do. So that's vague and overbreadth and vagueness. So of course, if a law is vague, we talked about the danger of unfettered police discretion. So now when you have a law that's on the books, but it's vague, that means now the enforcement of that law is going to rest on not even enforcement, but the application of the law is going to rest on law enforcement. So now law enforcement gets to determine what a certain conduct is, as opposed to the courts or the law itself telling us exactly what we can and can't do. So when we have law enforcement out here and they don't have definite standards, that now allows bias to creep in. So instead of, if I'm a law enforcement officer and I like country music and hate rap, I see a group of kids, black kids, pull by me in a car, and I pull them over because they have loud, for no other reason than they have loud rap music. And I don't like rap music. The question is, were they loud actually based upon some set standard, or were they just playing music that I could hear and I didn't like it? You know what I mean? So we want definite standards, and that would be with noise ordinance violations, right? So you can't have a noise ordinance violation that just says you can't play your music too loud, because at the end of the day, what is too loud? So it'd be better if they said you can't play your music over 40 decibels, right? Then that means they had, the police officers would have a decibel reader that would essentially tell him or her how loud your music actually was. So that's what I'm talking about. We have to have standards, so the police just can't do what they want to do and enforce the law against who they want to enforce it against. Also talked about equal protection, and the equal protection analysis. We talked about the standards to apply in determining the constitutionality of laws that differentiate or treat people differently because of certain characteristics. Of course, as a part of our flow chart or our set of questions, going from question to question, the first thing we ask is, does this law differentiate based upon anything? Does it treat one group of people different than all others? If it does, then the next question is why? Why does it treat people differently? If it treats people differently based upon sex, sexual orientation, or gender or sexual orientation, or if it treats people differently based upon age or illegitimacy, then in that situation, or disability, age or disability, then the next question you say is, okay, well, since it differentiates people based upon age, we're going to apply the rational basis test to determine if this law is constitutional or not. If you're looking at the law and you're trying to review whether it's constitutional, and you ask yourself the question of how does it differentiate, and you say it differentiates because of sexual orientation, or what else, or sexual orientation or gender, then you ask yourself, you say, well, that law treats people differently because of sexual orientation or gender. So at this point, what level of scrutiny do I apply? You apply intermediate scrutiny. And that means must be reasonably related to an important government interest. Then you move down and you say, not reasonably, substantially related to an important government interest. Then you move down and in your hypothetical, you ask yourself, does it differentiate? Yes, it differentiates based upon nationality, race, or religion. At that point, we all know that means we're going to be applying the strict scrutiny test to determine whether or not this law is valid, and you apply the strict scrutiny test. So that was chapter 2. So I'm harping on that because I know we touched on that in our writing. So chapter 3 talked about punishment and sentencing and how that goes. Talk about sentencing guidelines and stuff of that nature. Chapter 4 is where we started to talk about the parts of a crime, what the definition of a crime is made of. Every crime essentially has an actus reus. That's a guilty act or guilty omission. Then after actus reus, we moved on to mens rea. So you have to have an actus reus, which is a guilty act or omission, with a coupled with at the same time simultaneous to a certain intent. So it must be done in either intentionally or what we call on purpose, knowingly, recklessly, or negligently. So one of those four categories, and those are the four mens reas that are exercised, that are I guess used or exercised by the model penal code. So you have your actus reus, and your actus reus must be simultaneous at the same time. So at the time the act was taken, there must have been the requisite mens rea that was with it. So you must have been committing the act with that mind state, doing something on purpose, or even doing something negligently. Then we also talked about concurrence, meaning that they must be at the same time. And then we talked about causation. So especially when you have result crimes like murder, let's say, or homicide, I was being general. So if you have a homicide crime, the result is that a person died. So because of the culpable act or omission, based upon coupled with some mens rea, we have to look and say, well, did that actus rea and that mens rea join together at the same time to cause a damage? In the case of a homicide, to cause a death. So the important word there is cause. Did it cause a death? So causation is also very important. So when we're talking about causation, the question, we have two levels of cause, what the but-for cause, or the cause in fact. So in other words, did your act or omission get us to where we are? In other words, just because your act was like the first domino or the first thing that happened that led to a set of events, doesn't necessarily mean you're going to be, held responsible, but it means you're the but-for cause. If a person is not if you ask yourself that question and the person is not the but-for cause in your opinion, that means they're totally not responsible for whatever the resulting harm is. Now, if you do answer and say, well, yes, they are the but-for cause, then that doesn't end your analysis. You have to ask one more question, and that one more question is, are they also the cause in the legal cause or proximate cause? What that means is the cause without any intervening, what I would call intervening or unforeseeable intervening circumstance that comes in and actually cuts the chain of causation. So if I'm like Dave from the hypothetical, if Dave hits dude, and of course he breaks his nose and messes up his face, has to get surgery, and he goes in to get surgery, and the doctor messes it up and does surgery on his heart instead of his face, and dies, of course, then you have to ask yourself, you can say, well, yeah, Dave is the but-for cause, or the cause in fact, but is Dave also the legal cause or the proximate cause? In other words, would it be fair to hold Dave responsible for the death when something intervened and may have actually caused it? So in that situation, you have to ask yourself, was the doctor's malpractice in that situation foreseeable? So it's all about foreseeable. So if I injure you, it may be foreseeable that you may have to go to the hospital. But certain levels of malpractice are not necessarily foreseeable because they're so kind of out of the water. Or so if a person is going to get their face surgery on their face, and the doctor messes up terribly and does surgery on their heart, that's one of those situations where that may not be foreseeable. But if the person gets essentially injured or dies because of an injury they sustained or that was a part of the injury you gave them, then that very well could be foreseeable. And that kind of takes me to the paper. And I'll go ahead and jump to that, and then we'll talk about the rest of the stuff. But for the paper, just to give you guys the answer, there's one main answer and there's an alternate answer I'm willing to accept if you got to the answer for the right reason. Anybody kind of understand what I'm saying? So the answer that jumps out, which is the right answer, unless you give me a counter argument. The right answer is that Dave was not responsible for the death of, I'm trying to remember, was it Dave and his wife hit the guy over the head with the bottle in the store. I don't have
Jim, I believe.
Yeah, Dave hit Jim over the face. So the reason that Dave is not responsible for the death, and therefore he would actually be charged with an assault of some sort, assault with a deadly weapon or some sort of assault, and not the homicide, is because Dave didn't die as a result. Of course, he was the but-for cause, or if he doesn't crack him over the face with the bottle, he doesn't have to go to the hospital. But once he got to the hospital, he died because he was given a clotting agent or something happened. Now, the reason it's kind of two answers is if you answer it that way that I just said, and you said it's essentially because he's the but-for cause, but not the proximate cause, because that clotting agent, and the doctor giving him the wrong medicine or messing up, you can argue that is unforeseeable. Now, there's also argument that of course a doctor messing up, you could argue that whatever mistakes the doctor made in giving him the clotting agent and giving him a medication that he might have been allergic to, that wasn't so far-fetched or so far outside of the what we call the realm of foreseeability. So of course, if you go into the hospital, there, if any surgery you go into, no matter how minor, there's a chance you might not wake up from it, right? So that doesn't necessarily mean that there is that you're cut off from the chain of causation just because the doctor made a mistake. So it's the but-for cause, and in arguing whether you're going to hold him responsible for the death and charge him with a homicide, or not hold him responsible for the death and just charge him with an assault. It's all about the argument has to be about foreseeability. So it's about causation and the foreseeability of the doctor's mistake that causes death, right? So that's really the issue at hand. So it's two possible answers that would be right. Writer's not a word, but the more right answer would be that he should be charged with what was that? He should be charged with assault, some sort of assault with a deadly weapon or something like that.
So whenever I just have a something to say after whenever you finish.
Go. Well, let me see. Let me pull up the question real quick. Hold on. That way, while we're on this part, we can talk about that and move on. Let me see. Mm-hmm. Sorry for these delays, y'all. Hold up. Trying to find the writing prompt. I may have to go to Blackboard. Hold up. On computer. All right, let me see if I can find it. All right. So I'll read it out. Dave and Tina were about to be married when, on the eve of their wedding, Tina called Dave and said she had changed her mind and was off to Barbados, their intended honeymoon spot, without him. Dave asked, "What about the other plane ticket?" Tina replied, "Oh, I'm taking my friend Jim. His muscle body will look much better than you with a tan." Dave started screaming into the phone that he would get Tina back and would kill Jim if he had to. Several weeks later, Dave was buying beer at the convenience store when Tina and Jim walked in with their arms wrapped lovingly around each other. They both looked tall and tan and young and lovely. Dave went up to them and demanded to speak to Tina alone. They just laughed at him. Dave grabbed one of the beer bottles and cracked Jim across the face, tearing off a piece of Jim's nose and causing extreme bleeding. Which was exacerbated by Jim's extremely thin blood. Before he could bleed to death, Tina rushed Jim to the hospital. The ER doctors administered a clotting agent and saved Jim's life. 10 days later, while having a procedure to restore his nose, Jim was given a commonly prescribed medication to which he reacted adversely, causing seizure and death. What, if anything, could Dave be charged of or convicted of? So that is the question. So you have to look at certain facts. Now, a big thing I said she rushed to the hospital, and I said the ER doctors administered a clotting agent and saved Jim's life. That means he didn't die right away. Then I said 10 days later. So at this point, it was 10 days later. While having a procedure to restore his nose, of course, he died because of he was given a commonly prescribed medication, which he didn't, he reacted adversely. So the question is, okay, Ms. Downs, the question now becomes whether or not, I guess the issue is whether or not, the real issue is whether or not the doctor's mistake or the clotting agent and him dying from seizures 10 days later was a foreseeable event enough for it to, or whether it was not foreseeable enough to cut the causal connection. In other words, to say, well, what happened was so far out left field, we can't hold, it would essentially be unfair to hold Dave responsible for that. Like, yes, he's responsible for cracking his face, but he already had surgery, saved his life, or they saved his life with a clotting agent, and the whole 10 days later, they go in and repair his nose, and then he doesn't, he reacts adversely. So I put a measure of time in there, 10 days, right? So there's arguments both ways, but really the answer I'm looking for is that he was not responsible for his death, and therefore he would be charged with assault. But if you did not say assault and you said it would be manslaughter or one of the homicides, either second degree murder or some type of malicious murder, but not necessarily first degree, then the reason you come to that conclusion, you have to come to that conclusion for the right reason. So that means you have to say that that's what happened, but it has to be because you deem that what they did was foreseeable. Because now let's look back at the verbiage. So this is the one question that kind of I'm allowing you guys to go both ways on, but you gotta, if you're gonna get that second answer, you had to really, really explain yourself. So they gave him a clotting agent. 10 days later, while having a procedure to restore his nose, he was given a commonly prescribed medication. So the fact that it was commonly prescribed, then, words like commonly prescribed means that it's foreseeable. Of course, he did tear his nose off, right? So of course, it's foreseeable that the doctors would now have to repair his nose. So in doing that, they gave him a commonly prescribed. So if you make those arguments and use those facts and say, well, I believe that that everything the doctor did was foreseeable, and it was a part of what would have had to have happened to Jim because of what Dave did to him. So you can argue that because it is foreseeable, a foreseeable consequence of Jim's action. I mean, of Dave's actions, then Dave should still be held responsible, even if it is 10 days later. So if you made an argument like that, I would accept that. So that there's one main right answer, and there's one answer that's only right if you explain it the right way. So it wouldn't be a right answer if you didn't talk about the foreseeability, and explain to me and at least argue that that surgery and stuff was foreseeable. So if you're not making an argument, then you're not going to fall into the correct answer category. That question was about causation. So I wanted to test whether or not you guys would be able to, because we talked about murder later on, but we talked about causation earlier on. I wanted to see if you can put it together and determine whether or not, I'm testing the rule of causation. So that's the but for, and if it is but for, then you ask the next question, which would be, is this person now the legal cause, which means the foreseeable cause or approximate cause. So it's 2 levels of causation. So that's what I was testing in that writing. So that's the writing. So now, since that was a part of one of the chapters, then we moved on to chapter 6, where we talked about parties to crime and vicarious liability. So parties to crime being the accessories and accessories after the fact, or the accomplices. Then we talked about vicarious liability when dependent upon your relationship with another person, whether it's contractual or there's some type of duty that you owe to that person. You may be held responsible for their actions. So if they commit a crime or do something and hurt someone, you may be held vicariously liable, meaning their actions are now your actions as well, and you can be your conduct or lack thereof in stopping that person from doing something could be criminalized. Then we moved on to chapter 7, where we talked about the inchoate crimes, what we call the beginning stage or incomplete crimes. We talked about attempt, conspiracy, and solicitation. We also then moved on to chapter 8, where we talked about justifications, essentially justifications and excuses. Justifications being, yes, I did it, but I was justified in my actions. I did the right thing legally. Excuses being, I don't know what I did because I didn't have the mental capacity to understand what was going on or what I was doing. So you see how they're different. Justification would be self-defense or defense of others, and excuse would be the insanity defense or the involuntary intoxication defense. Had the midterms after chapters 8 and 9. Then we moved on to chapter 10, 10, 11 interchangeably, depending on what book you have. But that's what we talked about: criminal sexual conduct, assault and battery, kidnapping, and false imprisonment. And then depending on what book you're in, the next chapter 11 would have been homicide, but in some books they're reversed. But we talked about those 2 chapters on the same night. So we talked about the varying levels of homicide and the fact that they're differentiated by the mens rea. So in other words, whatever the mental state was when the person committed the crime, that's going to change whether it's going to be a whether it's going to be a manslaughter or negligent homicide or a first-degree murder. So we talked about those. Then we moved on to chapter 12, where we talked about crimes against property or real property, where we talked about burglary, trespass, arson, and mischief. Then we talked about crimes against property or personal property. We talked about larceny and things of that nature. Then we moved on to white-collar crime, where we talked about embezzlement, securities and exchange fraud, or what they call it, insider trading and stuff like that. Then we moved on to chapter 15, where we talked about crimes against public order and morality. And then and that's when we got to the discussion about victimless crimes. And there's also some historical context in victimless crimes And those are essentially crimes where no one is bothered or no one is harmed, but it's just a crime because the law says it's a crime, or the people in general, the majority says we're going to make that a crime. And I talked about the history of how a lot of that came from racism. And then last but not least, last week we talked about chapter 16, which was crimes against the state. And what I want you guys to know is the only crime that is defined in the Constitution. Anybody know what it is? Anybody want to try to tell me what the only crime is that is defined by the U.S. Constitution? Somebody.
Treason.
Treason. Good job. Treason is the only crime in the U.S. Constitution. I mean, that is directly in the United States Constitution. So that is pretty much it. That's what we learned this semester. Of course, you know, I had you guys show up for some extra credit opportunities where we talked about some current events, the Breonna Taylor case. Also had some discussions about policing, a panel or two. Then we had the departmental meeting. And that's another thing I have to talk about with the department. I don't know if you guys have heard, but there was some bad news. The chair of our department, Dr. George Johnson, passed away this morning. I don't know who has heard. So if you guys were on the departmental meeting that night, the full body meeting, he was definitely there. Of course, not physically, but he was on the Zoom. So you guys have had, if you were there, you've had interactions with him, and he was interim, so he was only kind of holding the space. Anyway, he really didn't want to do it full time. He was just like, hey, I'm retired, I'm chilling, but I'll do it for the chancellor. So he held that space and kind of kept us afloat as a department for the past 2 years. He's been here, not 3. Yeah, at least 2 years he's been here. So very good guy. He used to be the dean of the law school over here at Elon. So he was they call him Dean Emeritus because he was essentially the past dean of the law school over here at Elon. So he has a storied career, or had a storied career in law and in education. So great guy. Tip my hat to him. So it's kind of surprising, but yes, he did pass away this morning. So I guess the department is taking it a little rough. So I know Miss Shields King is definitely taking it rough because she was the admin and would have worked with him every day. So just be mindful of that when you're sending emails, and trying to get people to do overrides for your classes. People are kind of down. As professors, we're down right now because our colleague passed away. And I don't know how many of you got to have a personal relationship with him and talk to him directly, but he was an amazing and pleasant guy. But that being said, so the way I'm going to grade your, when you look your grade up on Blackboard is just going to give you your tally or your score. Do not rely on Blackboard to give you the actual letter grade. That is not where your letter grade is going to be. The letter grade is going to be found in AggieAccess.com. Or Aggie Access. That's actually where your grade is. So when I put your grades in there, that's your grade. So if you want to know, of course, you have the grading scale that I gave you in the syllabus, the plus minus grading scale. So what I use Blackboard for is for you guys to be able to keep up with your own score. So if you know your score and you know the grading scale, that means guess what? You also know what your grade is going to be. I never give anybody, a lot of times I'll never give anyone a grade below what they earned. Sometimes I give people a grade above what they earned. But for the most part, you get what you earn. And it just depends on, other things, extra credit and stuff like that. But you're great. So I'm going to put in all your extra credit. So I still have the master list of all the extra. We had 3 extra credit events. The full body meeting, the policing thing I was on, where y'all sent me the pictures and I took your names down. And then the last event we had about the departmental event where we talked about Breonna Taylor. So if you guys were on those and checked in, and everyone that sent me a direct message, I kept up and I checked in and I checked your name off or put your name on a piece of paper. So what I'm going to do is go through and tally those because some of you are in multiple classes. So I want to give you your credit for all the classes. So you got 5 points for each event that's going towards all of your classes. So if some of you guys are in 2 classes, that means you got 5 for one and 5 for the other as well. So I just have to go through and do that. So I'm going to do that. But that's how the grading is. If you have any questions, you guys have my mobile line on the syllabus. I'm not going to say it out loud because this is being recorded and it's going to be on YouTube. But you guys have the syllabus. You know how to find me. Also via email. I know I was a little bit slow this weekend if you did email me because I've, ripping and running, and it was my weekend. It was my time. Yes, I should have the grades for the writing up tonight. So those should be up tonight. I'm actually still working on those now. Kind of took a break to teach to talk to you guys now. So I think that's about it. I think I covered everything. Yeah, I think that is it. Anyone have any questions before we close this last Zoom out? On Aaron, you got your hand up.
I did about the paper, but you can, whoever that was, you can go first.
Aaron, yes.
I just wanted to know, so for the paper, I said that it was assault with a deadly weapon, battery, and second-degree murder.
Well, that's the thing. You can't charge him. So you wouldn't charge a person with assault if they're charged with murder. So the murder, a murder is or a homicide is nothing more than a completed assault. It's an assault with a certain what I would call consequence or a certain result. So you don't see people charged with assault and murder and the homicide. They're just charged with the homicide. So you wouldn't be able to just pick everything and say, well, I charged with assault and murder. So it's kind of either or. So if you charge him with murder, you don't have to charge him with assault because he assaulted him and he died from that assault. So that makes it murder. Or it makes it a homicide. If you're going to say that he's not responsible for, if you're going to say he's not responsible for his death, so essentially by only charging him with assault, and it is either or, if you choose assault, you're going to generally get the right answer. Because of course, you can always make those arguments. He died 10 days later. It was a clotting. It was something the doctor did wrong and not anything that Dave did wrong that actually caused his death 10 days later after they saved his life. So if you make that argument, that'll give you that's the general right answer. But if you say no, it's murder. So he can't be guilty of both assault and murder. You got to choose one.
Okay.
So because if you chose assault, that means he wasn't responsible for his death. If you chose any one of the murders or any one of the homicides, that means he is responsible for his death, and that kind of the assault kind of merges with the homicide if it's homicide. So of course you hit him over the head, that it's assault, but he died. So now the assault and the murder go together. So you can't charge. So you have to choose one or the other. Is that
okay? But so what about if it was like assault with a deadly weapon and it's still battery, right? Because I thought the assault was just the thought of doing it.
So I'll allow you to use assault and battery interchangeably because we always do. But assault and battery are different. So assault is when, for someone to be guilty of assault, that means the person that they assaulted had to know that they were being assaulted. In other words, it's not just they hit them, but they had to be placed in apprehension that they were going to be hit. So if someone doesn't know it's coming and you hit them behind the head, technically that's not an assault. That's a battery. So battery is just the harmful or offensive contact, no matter whether they know you touched them or not. Even poisoning someone. If you put some laxative in someone's drink and they drink it and they don't know they drunk it and they go have the runs later on, that is still that is what we call a battery. So they didn't have to be in imminent apprehension of it, but there was a harmful offensive contact that you made through that through that substance. So is that understood?
Yes, thank you so much.
Okay. Any other Ms. Watlington, you had a question?
Yeah, you kind of answered it. I mean, so for my answer, I put that, he'll be charged with assault with a deadly weapon. But I also said he would be charged with second-degree murder. And I explained why I thought that way. because, second degree murder is killing with malice but without premeditation, and it may
Mhm.
include a death resulting from an intent to cause bodily harm. And so that's why I thought it will also be second degree murder, because he did intend to cause bodily harm when he decided to use the beer bottle to hit him. And then I was like,
Mhm.
even though the doctors technically administered the drug that killed him, he wouldn't have been in that situation had he not been hit over the nose. Like, if he didn't have to have the procedure, he wouldn't have been killed.
Yeah,
So
but that's the but for. But remember, once you have the but for, then you have to ask, is he also the proximate cause? So it's obvious that he's the but for because they hit him in the face and caused the damage.
Yeah.
But then you have to say, is he also the proximate cause? So
And I talked about proximity too,
Mhm.
but and I guess I don't know. I talked about proximity, and I guess I just overdid it. I don't know.
It's fine. So I mean, with answers like that, I'm not going to ding y'all. I mean, because at least it sounds like you would have still had to give a full and a good rule statement and and a good complete rule application. It's just in general you have to pick one or the other.
Okay.
And I won't give you guys too bad of a ding for choosing both, only because the question doesn't say pick one or the other. It just says what, if anything, would he be charged with. But technically, you can't be charged with both. So I won't give a full ding for those. I'll kind of it'll be like a partial deduction, but it won't be anything crazy. Especially if you explain yourself well and explain both sides well. Now hopefully you would have. Now, hopefully, if you were going to do all that, you wrote issue-based writing and not contention-based writing. Because, of course, if you're going to come out and not be sure or give two answers, hopefully you would have given me an issue statement as opposed to coming out with the. So you see how when you're using contention-based writing, that means you're coming out with one definite answer and you're telling me why. As opposed to issue statement, you're saying, well, the issue is whether or not he was the cause or whatever, and you go through and you say, well, it could be this or this. Now, of course, for you guys who want to go to law school, you're gonna have to come up with an answer. So you're not gonna be able to. It's not gonna be both.
Okay.
But I won't ding you guys too hard for that.
But I did write it as I had an issue statement,
Okay.
and I talked about what he could be charged with, but what would actually, stick or whatever.
Yeah. So, and with issue-based writing, it allows you to, we call it the brain dump, where you get to tell us everything you know about whatever body of law you're talking about, even if it's not necessarily applicable to this. So it's almost, we call them brain dumps, because you want the professor to know when they're grading your paper that you know what you're talking about, right?
Right.
I look, professor, I listen. I know about this and that. So some professors, in law school, you have to. It depends on what professor you're writing for. Somebody's in the chat, but it depends on what professor you're writing for. Okay, Ms. Thompson, but it depends on what professor you're writing for. So you have to know your professor. So the only way to know your professors before you start doing graded essays and doing exams is you have to take them writing samples. You have to take them. Once you get a body of law under your belt, you have to go to them and write an essay, and essentially find an essay. So, you get into law school. When you go to law school, there are always going to be these supplements and books that go with certain classes. And there's certain that you're going to find books that just have law school essays on certain subject matters. So that way you're able to test yourself and answer essay questions, and give your teacher the essay. So they see the essay prompt, and then you write your answer out and you go through it with the professor. They'll read through it with you. You talk about your reasoning, and that way in that conference you can know how they think. You can know what they want because you've written for them. They can tell you whether they like your writing or they would like you to whether they like a brain dump or whether they just want the issue, and anything else that you talk about outside of that small narrow window is going to make them mad. So you need to know that. You need to know that for each professor. So there's no, IRAC and CRAC writing, that is like the skeletal structure of your writing. But when you get to law school, you're gonna also have to learn how to write, how to use the IRAC and CRAC, and how to use it for each individual professor, like how they like it, to maximize your grade. So I know that seems kind of overwhelming, but believe me, it's more doable. You know, if you go in there as a good writer in general, you'll be fine. Any other questions?
My question is, it's not so much of a question. I just want to make sure that you got my name down for attendance because I came in kind of late.
Let me see. Who else came in late? I got you now, Ms. Dodd.
All right, thank you.
Anyone else come in late? Think everybody okay? Everyone else is already spoken for. All right, there are no further questions. I will say this was a great experience teaching you guys. Would have been much better if it was in person, but that Rona is out here. Don't nobody want that Rona. Ain't about that Rona life. So we're just trying to be protected, and you know, so I think the way we had to learn this semester, it was the best. We had to work with what we had, right? I think these Zooms, hopefully they were very helpful. I tried my best to give you as much as I could, right? You know, I pre-recorded lectures so you could listen to them at your own time. I also got on here, so if you had questions, we could talk and interact in real time. So I try my best because I know everyone doesn't learn the same. I am cognizant of that. Some people don't like for you to give them, have to walk around and read or listen to something or look at something. Some people are cool with and want to get everything in person and have the conversation. And that's why when I record my lectures, I like to make them conversational, even though no one's talking back to me. I like to, I like to teach as if we're chopping it up on the corner as opposed to me being rigid and stuff like that. So hopefully my lectures were understandable. So if they weren't, please tell me. But we tried our best. So it looks like for at least the near future, I know next semester, this is going to be the same thing. So I want you guys to get accustomed to it. I know this was kind of new for you guys. I know for you guys that were already A&T students last spring, of course, in the middle of the semester, everyone kind of got pushed into online learning, on the fly. And I know that was hard. And this being your first full semester I know some people have in-person classes and some people have, or just have both, right? But this is the first semester where this is kind of what it was. Like all my classes are online. But what I want you guys to do in future semesters, because this was kind of a test run for a full semester, you guys have to get accustomed to now changing the way you have to do your work. So if you were in front of me, when I taught my classes in person, of course, you guys would have been in front of me in person once a week. I would have chewed you out if you did something wrong. I would have been there in your back pocket. Hey, what you doing? Look at the syllabus. All that stuff that us old people do to get on y'all's nerves, like holding you accountable. So, but in doing that, I would have been doing it in person, and it would have almost been like having me around you all the time in your ear, blah, blah, blah. But it's different. And I noticed there was a slippage even from some students I've had before that were normally good students. And I know this is weird. We're all kind of suffering from this, COVID, this what I call it, post-COVID traumatic stress disorder. But you guys have to hurry up and get accustomed. If you're going to continue to be good students and work up to your standards, you guys are going to have to adjust. That's what it is. You know what, Mackenzie, you're an athlete, right? You play volleyball. You guys can get ready for a team. Then when you get ready to play them, they do something different. But you got to adjust if you want to win the game, right? So that's how it is. And I'm just saying that athletically. I don't know who else is an athlete in here. But I want you guys to be able to adjust and adjust to this online learning thing, okay? Do your work, because you don't have your professors now on you all the time bugging you. We're not in our office hours when you don't see us walking the halls like, hey, you do my assignment? Hey, you know what's due tomorrow, right? We're not on you like we used to. Now you have to be on yourself. This is literally adulting at its highest level. Not its highest level, but at a pretty high level, it's adulting. So, like I said, I tell you when something's due, and everything was in the syllabus, and I literally planned my syllabus for the semester. So everything would be due and everything would be posted at that time. So it's very important in future semesters, if this is how it's going to go, print your syllabus, print your syllabi is plural for syllabus, print your syllabi out, have that, and be marking down. If you notice, I'm a marker. You see how I got them checks on the side? I know what's due. And even as a professor, I got to stay on top of it. So what I'm giving you guys as a parting gift is that knowledge. It's probably going to be like this for the near future, at least definitely next semester. So we're talking, you might be another 2 semesters in this whole COVID learning thing, right? So I don't want anyone's grades to slip because you couldn't adjust. This is boys telling you, you got to adjust. It is what it is. We have to adjust as professors, and you guys have to adjust. So that's my parting shots. Aggie pride to all you guys. I wish you nothing but success, whether you are a transfer student or a student just taking this class online from another university. You have taken the class at A&T, so you're Aggie now. So just welcome, Aggie pride. So y'all be good if y'all don't have any questions. We good?
We have
Thank
class tomorrow, right?
Yes, thank
We
you.
do. Yeah, this is just the end for this class. If you're in the other classes, show up. I'll see you tomorrow.
Bye.
Bye.
Hey, boys.
Bye,
Yeah.
attorney boys. Thank
Take
you.
care,
Hopefully, I
Stacia.
see you around the
Thank
way.
You.
We will.
Thank
Have
you.
a great
Bye.
one.
Thank you.
Take care.
Thank you, Attorney Burke, boys.
Yes.
Yeah. What was I about to say? Yeah. So I just want to make sure I get credit for the panel we was on together.
Yeah, I got you for
'Cause
that. Yeah.
Okay. All right. And a guy named D Covington.
Yeah, there's your D. I know
Yeah.
D.
Yeah, I work with him. He just told me about you
Okay, that's
earlier.
my guy, man. We go way back. This is my Mason brother. And
Yeah,
he was
he
a little
just
bit
told me.
behind me at A&T, but I known him for a while. Good fella.
Yeah. That's all I wanted to say.
Okay. Did you get that practice stuff out to those to everyone that was interested in mock trial?
I did.
Okay. So maybe next semester we can do more meeting. I just had to get used to this. This is different.
Got you.
So I think we can probably do some Zooms or something next semester and start at least talking about the process
Okay.
of preparing. But it's really hard to do mock trial without being in the room and stuff like that. It's really weird. So, but we'll work.
Yeah.
We'll work on it.
All right.
All right. Be good, man.
All right, man. I'm going.
Take care. CJ, you good? Yes, sir.